General Carignan is not going to do her 5 minutes. She's asked us to proceed directly into questions. So thank you for that. And I'm going to start us off with Mr. Anderson. You have 5 minutes. We're going to do 5 minutes all around for each one. Okay?
Sounds good. Thank you very much. I would like to return to the communication between police forces, if I may. That's more of a technical question, and it's not covered in C11. Can you explain how this would be dealt with?
Mr. Chair, thank you for the question. Police corps do consistently communicate and coordinate their activities together. So for access to a base for the needs of investigations, they speak and they enable their access to everything that the civilian police would need to conduct their investigation. So we have done this regularly in the past with other type of charges and allegations, and of course this would apply to the same system would apply for this type of charges.
And just to return to the bill specifically says the military police cannot collect evidence. So I'm wondering, how do you deal with that, Mr. Holm?
So I may be getting ahead of clause by clause, Mr. Chair, but there actually are provisions in Clause 8 that deal with the ability of the military police to collect and preserve evidence while they're waiting for or before they transfer. So there's an immediate responsibility, even within Canada, for the military police. Excellent. That's found in Clause 8 of the bill.
Thank you. Since December 21st, criminal offences of a sexual nature have been transferred to civilian authority. Do you have data on how many cases? I think we were going to move that one over.
So I have some data that I can share with respect to the number of cases tried in civilian courts since that time. I also have data with respect to the 5 years leading up to the implementation of the interim.
Okay.
And so in those 5 years, on average, 300 to 350 investigations conducted by the military police in that time, and a total of 44 prosecutions. So an average of about 9 a year in those 5 years. Since then, the numbers I have with respect to prosecutions are in fiscal year 22-23, 13 prosecutions of what are the sort of offences that are in the bill now, and 7 in 23-24. This is as you're seeing the sort of implementation of the Director of Military Prosecutions directive that he would no longer prosecute any cases within the military justice system. And so there's a ramping down. That said, there are 4 cases that remain to be tried in the military justice system. Those charges were all charges that were stayed several years ago. Those stays were lifted by the Supreme Court of Canada in a decision last year. So this is getting back to completing those cases within the military justice system.
Perfect. Have any cases been thrown out due to the Jordan framework?
So I know only of those ones that are in the news. There was one in Pembroke that was fairly notorious that had, with the victim's request, been removed from the military justice system, transferred to the civilian justice system, and the judge found that the 9 months, that had proceeded in the military justice system counted against the jeopardy for the accused, added them to the Jordan framework, and stayed the case. I'm not aware of any others.
Okay. Does the Victim's Bill of Rights present any concerns for the ability to pass information back and forth between the military and civilian systems?
So the Victims' Bill of Rights is mirrored by the Declaration of Victims' Rights within the military justice system. So the same provisions apply back and forth. It doesn't provide very much in terms of sharing of information. It's mostly about the rights of victims to access information about their own case and about people involved in their case. But it doesn't impose an impediment to the sharing of information, no.
Okay. What actions will be taken by the CAF by the CAF to ensure victims are protected within their workplaces as things are being adjudicated by the civilian? And this has, of course, to do with communication as well.
So this is, I think, consistent with the answer that I gave you in the last round, and the Chief and CPCC may wish to talk about that as the actual commanders at the table.
Okay.
So currently, the chain of command is dealing with the sexual misconduct and sexual assault cases in various ways, depending on what they are facing. So victims keep agency over their own situation, and the chain of command does respond to that, depending on the victim's wish in dealing with their own cases. So the chain of command, there's been training ongoing to ensure that we dealt in an appropriate manner with all victims and all cases, how it's reported, what to do with the information, guiding the victims towards the support that they need at the SMSRC, providing all types of, again, depending on the level of support that the victim is requiring, and ensuring also the safety of the victims as the cases are being reported.
Thank you, General. Thank you. Ms. Vivian Lapointe, you have 5 minutes.
Start with 5.
We know that culture change within the Canadian Armed Forces has been a central focus of your leadership. How does Bill C-11 align with the work that is already underway to build a more inclusive and a respectful culture across the forces?
So the bill allows for more clarity of jurisdiction for victims. So there is one clear path, and it is via the civilian system. So there is no more gray zones, and this is what Madame Arbour was going after in her recommendation 5. And also the demonstration that it was independent from the chain of command. So providing that independence, transparency, but also a clarity of jurisdiction. So there can't be any questions as to what is the correct path through justice.
The legislation formalizes the victim liaison officer role, and it also enhances supports for those affected by misconduct. How do you see these new supports complementing the work of the Sexual Misconduct Support and Resource Centre and the efforts already underway within the forces to improve survivor care?
So this is part of the how victims are accompanied during their path to justice, ensuring that they have the appropriate support to navigate the justice system and getting the appropriate level of support as they go through this path.
As the forces transition to this new framework, training and awareness will be very important. Could you speak to how Canadian Armed Force members will be supported and how they'll be prepared to understand and implement the changes that are being introduced through Bill C-11?
So every time we introduce new legislations or changes, we also ensure that appropriate training is delivered to our members to understand the differences. So this is going to affect a number of organizations or individuals as part of this transition, and communication, and again ensuring that people have the appropriate training to ensure that this is the transition is affected in a positive way.
Now, sustaining progress over time is key to ensuring that culture change takes root. How does the implementation of Bill C-11 fit into the longer-term effort to make the Canadian Armed Forces a safe and inclusive and trusted organizations for those who serve?
I think what is most important is as we introduce changes, whether it's new legislations or new initiatives, we want to make sure that we actually measure the effects and impacts of those changes. So we have designed a structure, processes, and a full organization that can do that in ensuring that those changes have actually the effect that we are anticipating or that the intention behind the introduced change. So we're going to be measuring the impact of this and ensuring that this is actually meeting the intent.
And embedding reforms like those in Bill C-11 directly into law sends a clear signal of lasting commitment. From your perspective as Chief of the Defence Staff, how does that kind of legislation action help strengthen confidence and trust across the forces, though?
I think this is mostly related to ensuring independence of the process, ensuring that victims are enabled and that they keep agency over their own a process and how they want to go about their own complaint. So it's about providing them an approach that respects the agency that they have over their own process and ensuring full independence of the justice process that they have undertaken.
Thank you, General. I'll now go to Monsieur Savard. Tremblay. You have 2.5 minutes.
2 minutes and demi.
2.5 minutes. Well, 5 minutes, okay. So I won't ask the same question as last time. I'll give you an opportunity to answer it directly. So that's 60 days to make sure that there are no delays.
Je sais pas si ça va être plutôt du côté.
I'm not sure if it's on the JAG's side. The Provost Marshal can answer the question. We are planning the stages to shorten that transition period. It's 60 days following royal assent. I'm not sure how to say that in French. We'll ask the interpreters.
Sanction royale.
Sanction royale.
C'est ça.
Royal assent. So 60 days after royal assent, jurisdiction is lost. There's a section that provides for another 60 days to finalize transfer. So that 120 days total period is enough to ensure that the victims have what they need within the civilian system. How to make sure that there are no delays within that system? Well, it's not within the bill, but as the Chief of Defence Staff said, that's part of our weekly communications, actually daily communications between the civilian police and military police to make sure nothing falls between the cracks. Are you saying both weekly, or on what basis were you saying? Based on my understanding, there is this discussion between the two police forces. The police forces on the bases are always in touch with the civilian forces, the police of jurisdiction outside the base. Okay, so maybe I can broaden the question a little bit. All of this will be quite an issue with respect to coordinating all of these forces. You've got the police and the provincial forces. You've got the military forces. You've got the department. There are many, many actors. Is that already in the plan? Has that been really thought out? There's that legal coordination, but there's also a financial side to it. Is all of that already provided for? That coordination currently exists between those police forces. There are ongoing discussions between the police forces as to matters of jurisdiction in various cases. Depending on the allegations, it could be the RCMP. At times, it can be municipal police forces. Sometimes it can be the provincial police forces, and all depends on the case. At this point, that coordination already exists. So it'll be about anticipating things now. The police forces are expecting this now. It's been a few months and actually a few years that this process has been underway. So once the legislation is passed, then just have to simply move to the next stage. I would imagine my time is up. Right, 5 minutes. Sorry, I forgot. That's why I've been stressed from the start of my questioning. Okay, another question. Can we expect to see some statistics to see how effective this bill is and the act and the changes with respect to the complaints, the transfer to the civilian side, the rates of charges, convictions, the degree of satisfaction among victims, all of that? Can we expect it? Yes, we certainly can expect that. In fact, between the professional misconduct and culture chief and the SMSRC, there is data is being compiled to follow up on the effects of the various changes afoot. So, given the number of complaints we receive, where things stand all the way to the courts processes, and also the trials underway will be monitored as well, because as soon as the armed forces member is involved, then we have to follow up administratively as to the person's career today and as to a future in the forces. So based on what I'm hearing, anything that affects the members, yes, correct. So I'm wondering, what are the factors that will allow us to assess the actual... Sorry, am I disturbing anyone here?
En fait, j'ai pas eu le temps de l'affiner. J'avais l'impression de déranger mes collègues.
Sorry, I was hearing my colleagues while I was asking the question. If they're uninterested, then, perhaps they could have their conversation outside. Now, my question is, the Arbor report was talking about a culture of impunity. So is there some assurance? I mean, what will we have? Apart from the statistics you're referring to, are there going to be reports? I know for the public, you internally, you do your own checks and et cetera, but we parliamentarians or the public in general, will all of us have access to this information? Go ahead. We'd certainly be in a position to do this. There are a number of reports. Martin at the Resource Census produces reports. The JAG also. We produce reports that are public. Now, with respect to culture and misconduct, we also have the CCPC, which I don't have the translation for. That's within the public domain. We publish data and incident reports. Nope, nothing is private there, but you can follow how things proceed through the system. We're starting to work more in depth on the data side. We have a lot of data, but there's some consistency issues. We address the problem first off, and now we have to look at how we'll want to measure these things.
Merci. Thank you, Monsieur. Ms. Gallant, you have 5 minutes.
Police need more training and experience investigating sexual crimes. Because if they're going to manage investigations outside of Canada, we need to know what the plan is to keep them trained and sharp.
So as we speak now, the military police has been ongoing specialized training to interview victims and deal with sexual assault cases. So they have been trained over the past few years, but the question probably would be better answered by the Provost Marshal. But they have been undergoing training, and this is part of what they do as they tackle sexual assault cases.
How much money does Defense Counsel Services spend annually providing legal services to CAF members accused of criminal sexual offenses?
So I don't have the answer at my fingertips. I provide them with 7 full-time regular force legal officers along with the director, but the director also has the ability to contract civilian lawyers that he uses in particular circumstances, so I will take that on notice and get you the answer.
Can you elaborate on the transfer process section of the bill? Specifically, how does the transfer of a detained person to the civilian authority take place, as well as the procedure for the collection of evidence?
So in the vast majority of the cases, members are not detained at the beginning of an investigation. So when a complaint comes to the military police, a complainant comes to the military police, they start their investigation under the interim policy that the CFPM has put in place. If the individual wishes to have the matter dealt with in the civilian system, they transfer it then, and the investigation is done by the civilian police. In any case, even cases where the military police are doing investigation today, the charges are laid in the civilian system. So if there are any arrest warrants that need to be carried out or served, they would be done within the civilian system, and custody would be reviewed within the civilian system, not the military system.
So what training and dollars associated with this training would go towards preserving the chain of evidence and the investigations?
So again, we'll take it on notice. Certainly part of the military police training at the Military Police Academy has to do with the collection and preservation of evidence and ensuring the proper trail of custody of the evidence before it is turned over. But we'll find out how many resources they put into that training.
So victims have expressed concerns with the cross-pollination, the sharing of information between the civilian and military systems. There have been cases where prosecutors and local civilian law enforcement bodies have passed on information to military ranks to quash or weaken the cases of victims. So what measures are in place to prevent this from happening in the future?
Information coming from civilian authorities back to military authorities?
Yes.
Okay. So privacy acts that are applicable in the provinces and territories are the primary piece of legislation that deals with the sharing of that information. I'm not aware of any particular cases of the sort that you describe, but I imagine that they would be completely inconsistent with the privacy acts or the privacy-related legislation of the provinces and territories.
What specific training will civilian prosecutors and defense counsel undergo to account for the difference in culture when taking on these cases? So military to civilian.
So I can certainly speak to the prosecution side of this, less so to the military police side. The Director of Military Prosecutions is part of the Federal, Provincial, Territorial Heads of Prosecution Services Committee, which has a number of subcommittees as part of it. Through that mechanism, there's a constant interchange and sharing of information with respect to the importance of the military justice system for discipline, efficiency, morale, those sort of issues. And in fact, in recent years, pursuant to a FISH recommendation, they've come up with a set of presumptions and principles that are publicly available, dealing with how to deal with concurrent jurisdiction between the two systems.
Regarding the collection of evidence portion of the bill, how would the legislation affect the distribution of rape kits to victims?
So they're not generally distributed to victims. They are used in hospitals by medical professionals to collect evidence. When that evidence is collected, once this bill is in place, that's not evidence collection by the military police. That would be evidence collection that would be turned over to the civilian police.
Thank you, Major General. Thank you, Ms. Gallant. Passing it over to Mr. Chris Mella. You have 5 minutes.
Thank you, Chair. I'm going to stay with the victim support angle here. Bill C-11 proposes to transfer jurisdiction over sexual offences committed by CAF members in Canada from the CAF to the civilian justice system that we've heard at length, expand access to victim liaison officers, and introduce enhanced protections for victims. What measures would be put in place to ensure that victims are supported during the transition of cases from military to civilian jurisdiction? To anybody who could answer. General Carignan? Or Monsieur Gravel, sure.
Yes, absolutely. Thank you for the question,
Yeah.
Mr. Chair. As I mentioned before, from the SMSRC's perspective, the supports and resources that we currently offer will continue regardless of the transfer to civilian justice system. In fact, I'll say that a lot of the clients that we serve right now, some of them are actually being dealt with under the civilian justice system already. One that we talked about earlier is the Independent Legal Assistance Program. Already since May that we're in our phase 2 with our internal lawyer, we've had 34 clients, some of which include people that are going through cases in the civilian justice system already. So we're well set up to continue with the same supports and resources.
Further to that, what role would victim liaison officers have in improving communications and trust between victims and the military justice system?
I'll transfer to my colleague at CPCC to speak more to the VLO program.
Yeah, so on the VLO program, what this legislation brings is it allows somebody to ask for a VLO on behalf of a victim. So that is the change with this legislation. The victim liaison officers are there to provide support to victims when respondents are, or where a respondent is accused of a service offense. So if this moves in, right now we're discussing how we're going to expand the program because our VLOs are really well versed into the military justice system and not the civilian justice system. So we're looking at how we're going to expand that program and how do we do that interface with all those services that are available in the civilian justice system as well.
Do I have some time? Okay. Further to that, then, Monsieur or General Prévost, there's been some concern we've heard from victims who now will have to rely on, and I think it's a bit of a patchwork quilt across the country of what sort of victim services are in place in the civilian realm. I know in my own riding in Bay Quinte, the City of Belleville Police, for instance, just onboarded and hired a victim services person full-time. That's not the case in all areas. So I guess there is some reticence from some victims who say they're not convinced that maybe the transition or those supports will be there for them when they take their case to the civilian system. What reassurances can we give them on that? General Carignan? Yeah, sure.
Yes, from our perspective, like all of our public service employees and CAF members have access to SMSRC support. So this is a firm support that exists regardless where they are in Canada. So regardless of which jurisdiction will prosecute the case, the SMSRC will remain as the firm support for victims.
Encouraging, thank you. Now, to General Holman or Ms. Beck, in addition to proposing to transfer jurisdiction over sexual offenses committed by CAF members from the CAF to civilian justice system, Bill C-11 would introduce structural reforms to the military justice system that are aimed at improving procedural fairness and victim engagement throughout the complaint and hearing process. How would the proposed structural reforms, including changes to hearing procedures, ensure that victims are better informed, supported, and able to participate meaningfully in the proceedings involving service officers, to whomever?
So perhaps Jag can add afterwards, but to be clear, the 24/7 line that currently exists is there available for victims all across the country and their families. And now, of course, the Coast Guard has access to our particular systems. We also have a well-resourced response and support coordination program that is there to help interpret, in fact, to accompany the victims through the processes, providing support, advocacy, and personalized case management. So all of that will continue.
Thank you, Deputy Minister. Appreciate that. Monsieur Savard-Tremblay, you now have 2.5 minutes.
Merci. Pour continuer.
Thank you. Let's keep going with the issue of coordinating all of these things, you were saying nothing new really is envisaged under this bill. There's another aspect that I was wondering about. There's still the option for military involvement for the conservation of evidence. And how do we make sure, and then again, that there wouldn't be intrusion in on the civilian side or encroachment? Well, the military police is well informed about their jurisdiction and their role to play. It will be on a case-by-case basis. You could end up with a situation that's an emergency. You immediately have to do something for the security of the victim, and that police officers can do so that military police can do that until the time comes to transfer jurisdiction to civilian police forces. In some cases, witness or victims may wait a few months before laying any kind of complaint, and they will see how they want to report on these events. The SMSRC is in a good position to inform victims as to what route to take. Take, for example, a victim who decides to go straight to civilian police forces without discussing anything within the chain of command. That's completely in line with what I was saying about victims having full control about the way in which they want to manage their complaint. That's what I mean. And that is something that we defend. And the victim can also choose to go to the chain of command, and the chain of command can take decisive action to make sure that the victim is safe. So there are a number of scenarios that are open to victims. Again, to make sure that the victim is fully in charge. I would imagine
I will now pass it over to Mr. Kimball. 5 minutes.
Thank you, Mr. Chair. Before you start your time, just for the record, it's Kimball, not Kimball. No M in there. Just
my apologies.
all good. Thank you.
You're not the first person I've ruined by way of their last names.
You've certainly not ruined me. I think I can recover. And thank you, Mr. Chair, through you to the panel. I just want to circle back to Canadian Warship being a sovereign platform. And you mentioned it was discussed that both in international and Canadian territorial waters, prosecutions would be under the military justice system. What about when that ship is alongside, say, the Port of Vancouver?
So alongside the Port of Vancouver, I think without question, it's in Canada. So the military police would have the authority to take those initial steps that are dealt with in Clause 8, but thereafter it would be the civilian police that would take over.
But in international water, it would...
So that's an interesting one that I think I'll take on notice, and we'll come back to you by the time we get to clause by clause.
Say at anchor, right? So that's
I know.
So there's just some areas that need some definitions,
and I had it going through my head after the initial question, and I think I understand the question now, and we'll have a better answer.
I think
when
that
we
needs
get to clause by
a
clause.
much closer look at to define what would be best for everyone in question. And a follow on to that, I know the Coast Guard is currently preparing to deploy, or already is deploying, with the Navy in the Arctic in Canadian territorial waters. Will the military justice system apply to the Coast Guard now that they're under and reporting to Department of National Defense?
The answer is no.
Thank
They
you.
are not members of the Canadian Forces.
Sorry, they are not?
They are not members of the Canadian Forces, so they may have it applied to them if they deploy, for instance, as people accompanying the Canadian Forces in that small sort of case, but not presumptively.
Thank you. And what mechanisms does the bill have in place to prevent a liaison officer from being a friend of the accused? The CF used to use retired and active members in court to liaise.
So for VLOs, the provision that's in there right now says that if unless it's impossible for operational reasons, commanding officer who's requested to appoint a VLO should appoint the person selected by the complainant. And so that's the one mechanism that exists right now to ensure that
will continue.
Correct. That'll continue to be part of the
Thank you.
Of the law.
There's no provision that prevents the VLO to be a friend of the member, but the VLO cannot be party, witness to the case.
Okay, thank you. C11 says that military police cannot investigate. What does this mean exactly, given the military police will most likely be the first responders on any in-base local incident?
So I'd refer you again, Mr. Chair, to Clause 8 of the bill, which actually provides 3 specific provisions of carve-outs of what the military police would be allowed to do that is not investigation.
So would they be allowed to secure evidence, for example?
Yes, they would.
And would they be allowed to take statements?
I'd have to refer to the bill itself, which they can do anything to the extent necessary to prevent the commission continuing a repetition, including making arrests. They can secure, preserve any evidence related to the offense.
Did that include statements?
It's not explicit in the bill as I am looking at it here.
Okay, so that might need revisiting as to what's the best method forward for statements. How will the military ensure the accused has adequate representation? Court-appointed lawyers don't necessarily have the same understanding and of military culture.
This is an issue that Madame Arbour recognized herself, but what she also recognized is concurrent jurisdiction, particularly over criminal code offenses, has always existed in Canada, with the exception of murder, manslaughter, and child abduction. So it's been a feature of that dual concurrent system that that the structure for provision of defense counsel services is only provided to folks who are dealt with in the military justice system. So at this point, there is no plan. The bill does not provide for the provision of defense counsel services to individuals where the charges proceed outside of the military justice system.
Thank you. And will accused members face internal administrative action while the case is ongoing in civilian courts, and who decides what that internal action should be while it's still a determination of guilt or innocence is being determined?
Yes, so thank you for the question. So administrative process can continue in parallel to the disciplinary process or the justice system, and it's up to the commanding officer of the unit or, in certain cases, to the formation to deal with those administrative measures.
It'll be each CO will have their own determination. It seems that do you feel that that would be a bit of a patchwork of arbitrary justice going forward?
In parallel to the justice system.
But each commanding officer would have decision over internal administrative actions.
Correct.
Okay. How will the Canadian Armed Forces maintain training and ability to prosecute cases overseas if it has no way to practice it here in reduced caseload as they're being transferred to civilian?
So the Director of Military Prosecutions has a very extensive training budget that can and will be used to undergo, to have prosecutors undergo training. Also, similar to my response with respect to the military police to one of your colleagues, the opportunity exists to second military prosecutors outside the prosecution service. But maybe the most important one, I would say, is we have some very experienced reserve force prosecutors within the Director of Military Prosecutions whose full-time day job for the Ontario Crown, for example, is as sexual assault prosecutors. And they are both available to prosecute, but also to train and mentor military prosecutors.
Thank you, Major General, and thank you, Mr. Kimball. Thank you. Mr. Kibble.
Kibble, no M.
Kibble.
Same as dog food, no M.
Yeah.
Doggy food.
Watchhorn, I think it's pronounced correctly. Over to you. You got 5 minutes.
Merci, monsieur.
Merci à vous.
Thank you. I'd ask the panel as a whole this question. Let's take the perspective of victims. Every case is different, but I'd like to know how a victim deals with things. Okay, first of all, there's a complaint. Something has happened. There's been sexual assault that she claims there's been sexual assault. How does she proceed? And how does C11 improve the whole process?
Premièrement, la victime a plusieurs.
First, the victim can come forward in a number of ways. If she trusts the chain of command, and in fact, the statistics seem to be showing that victims have greater trust in the process, even though there's still some issues. But they can turn to the chain of command. They can also go through the SMSRC. We also have 16 centers within the country where people can bring forward these charges. If it's a criminal offense, then the victim can be accompanied also on the civilian side. As a follow-up, I'd like to understand how this works with the victim liaison officer. How do they interact with the victims and with the court? Thank you for the question, Mr. Chair. I'll defer to my colleague for the liaison officer side of things. But within the center, if a victim contacts us to discuss an incident, something happened, the first thing we want to do is provide tools for this person to take the most informed decision. And that includes the option to have a victim liaison officer with them. What does that look like? And the intent is really to inform the person so this person can make his or her own decision as to the path ahead. Provost General, with respect to liaison officers, as I think I mentioned earlier to your colleague, there are 136 liaison officers in the forces, and they've accompanied people through several cases with our members. They have a very trauma-informed approach, and the program aims to accompany victims through the military justice system. Now, with Bill C-11, sexual assault cases are removed from the military justice system and now transferred to the civilian justice system. And we are now looking at what to do with our liaison program, because the system is very different. Our liaison officers are trained within the military justice system, and that's distinct, very different. So how do we help? Do we simply transfer services because civilian side courts have support for victims? Do we just do that transfer? We're looking at that. We're looking at that question. And if I can add just one thing, what the bill would bring as an additional benefit is that the liaison officer program is not just for the victim, but for any person that the victim appoints. Okay, so a victim could appoint a loved one or another person to interact with the victim liaison officer? Correct. Perfect. Do I still have time? 1 minute? Okay. In the bill, we hear about structural reforms with respect to hearings. Are there any changes to procedures at the hearings that would mean victims would be better informed, better supported, so they could significantly take part in any procedures with respect to military justice, the military justice system? Look, I'm not 100% clear on the question, nor even Mr. Mallet's question earlier. The hearings for sexual assault cases are now under the civilian courts and not the military courts. So perhaps one of the improvements or benefits of this bill is that it grants victims some certainty, that is, the complainants also some certainty as to what justice system, what police forces will be investigating. And the hearing will happen in the civilian side. Thank you very much. Thank you, Mr. Chair.
Mr. Bazan, you have 5 minutes.
Thank you. Always gets money right. One of the few. So thank you again for all the witnesses for being here, and thank you for your service to Canada. General Provo, as the Chief of Professional Conduct and Culture, I understand that you have a stakeholder group that you will consult with from time to time that are more, veterans and civilians and that. Did you consult with them on Bill C-11?
I did not consult with them on C-11. I was not involved in Bill C-66 at the time, but Madame Arbeau did extensively discuss with victims, and as Bill 66 was crafted, victims were consulted.
Okay, thank you. The minister said that he had no clue why he has been given the power to intervene on cases, giving ministerial directions, a power that lies right now with the JAG. And as the JAG, you're losing oversight, or you no longer will have the director of military prosecutions reporting to you, since they'll report to the ministry. You'll no longer have the director of defense counsel services reporting to you, since they'll report to the minister, and you're losing the power to give direction on prosecutions. So the minister is saying he doesn't know why he's been given these powers, and so I would like to kind of get an idea where this is coming from.
Sure. Well, to start with, both the DMP and the DDCS will remain under the JAG's general supervision and will be subject to general instructions in respect of how they do their duties and functions. So the change that's being made is in respect of the Director of Military Prosecutions, where it will be the minister who will have the authority to give case-specific instructions to the DMP. So that was a recommendation of Justice Fish, and Justice Fish based it on drawing the analogy of the Director of Public Prosecutions of the Public Prosecution Service of Canada and the Attorney General. And so effectively, the minister now sits in the role of the Attorney General in respect of giving case-specific instructions. I will say that, like the case currently with the JAG, any specific instructions given by the minister are presumptively public, and so there would be transparency, as there would be in the event I ever used the authority to make those instructions.
Okay. Flipping through Bill C-11 here, and we talked a lot about that, civilian courts and police agencies will, of course, be potentially collecting evidence or get it from the military police. I don't see in Bill C-11, though, where access is granted to municipal police agencies, provincial police departments, or even the RCMP. Do they get access under the National Defense Act today onto base?
So they do
have
now.
To get permission?
Yeah. So they are given access when they need access to conduct investigations today, and that access would continue.
Who makes that decision?
So the local base commander has the authority.
So the base
to make
commander
that
could
decision.
deny them access to the base if he doesn't believe that they have a case to come forward on to investigate.
There would have to be a rationale for doing so that would outweigh the benefit to the public of having the investigation done. And certainly the the civilian police, if they felt like they were being interfered with, would have a number of mechanisms to deal with that, including
Should we
going up the
not
chain.
be defining that in the Act then, that if we're no longer going to provide or not allow military police and National Investigative Service to actually do any of the investigation, shouldn't we be making sure that within the Act that there is access granted for all requests immediately as defined by legislation rather than at the discretion of a base commander?
So I leave that to the wisdom of Parliament. What I would say is, with concurrent jurisdiction now, the Act is silent, and the civilian justice system has access as required. Even where there is sole jurisdiction over murder, manslaughter, child abduction offenses, I'm not aware that there have been any problems with the military police having access.
Military police, you said. I'm talking civilian.
Sorry, you're right. Civilian police
Okay.
is what I meant. I apologize.
Now, we did talk about, everything's going through the civilian system and potential administrative measures taken, but if somebody is found guilty in the civilian system, sexual offenses, wouldn't that also automatically trigger a court-martial?
Not a court-martial, but it would certainly give a clear ability to release someone from the Canadian Forces under the release provisions dealing with misconduct.
Okay. So
Thank you. Thank you, Mr.
Point of
President.
order,
Yes, Ms.
Chairman.
Chairman.
So I think I was maybe perhaps being too polite and oblique when I was asking the question about the rape kits. So specifically, I wonder if you could reply in writing as to how we can ensure that victims, if they're on exercise or if their base does not have a hospital, how the evidence can be preserved by getting the procedure done as soon as possible. How is that going to happen?
Can you bring that and perform that in writing? Thank you, Deputy Minister. Ms. Sierra Ramonado, you have up to 5 minutes.
Mr. Chair, and through you again, thank the witnesses for being here. General Carignan, we hope that members never need this provision or this service. However, while we've been, since 2021, moving those cases, investigations to the civilian system, it's been since 1998 that the Canadian Armed Forces were investigating and prosecuting sexual assault. Is there a plan in terms of communicating to chain of command, local police, etc., the new measures once C11 receives royal assent? For instance, I'm assuming that if you were to speak to a regular police officer somewhere in a small city in Canada who is who a victim has come forward to and says, I'm a member of the Canadian Armed Forces and I would like to report her. What is the provision in terms of educating them that it's not the military that is actually now going to be responsible for the investigation and prosecuting? Is there a communications plan, I guess is my question, with respect to educating civilian authorities and also victims of that new process?
So there's many folds to the question of communication. So this new way of doing has already been undertaken in the many provinces. There's been numerous consultations done with the provincial authorities throughout the last few years as this change came about. So this will definitely continue. On our side, we will make sure that internally to the Canadian Armed Forces that the new process is well understood, that the transition is occurring, and that the chain of command know where to go when complaints come forward. So this process will definitely be extremely important as we move forward in the transition. So the communication aspect of that will be absolutely key to success.
And Deputy Minister Beck, you mentioned the 24/7 support line for members, and many of you on this panel kept mentioning members. My question is, what if the victim is no longer a member of the Canadian Armed Forces and left because of sexual assault, and after this legislation passes decides to come forward? Do they still have, as veterans, access to the SRC or victim support or that the victims' VLO services?
For the question, absolutely. Veterans, families as well, families of the victim, families of the members. The communities that are involved, we know, are often deeply hurt by what has happened to their family members, so equally important that they have access to all of our structures in place to provide support. Again, that 24/7 phone line is for family members as well.
Perfect. And in terms of the implementation, the comprehensive implementation plan where 36 of the 48 recommendations from former Justice Arbour's external review has been addressed. I know that the goal is to complete them all by the end of this year. This bill also includes strengthening the independence of the investigation and the prosecution. Could you elaborate a little bit why that's important in terms of building back trust?
So as concerning recommendation 5, more specifically, This was the reasoning behind Madame Arbour's recommendation. Is to ensure that level of independence from the chain of command and ensuring victims' agency over their own complaint. So that is all the reason for this this to proceed in that way. But also, there's many pieces to this. As we can see as well, the SMSRC is also independent from the chain of command and completely confidential, which is completely administered separately to ensure, again, privacy and ensure that victims have agency over their own process.
Thank you, General. Thank you, Mr. Raminato. I know time is coming out. Mr. Roseanne, you wanted to interject?
Just one quick question, and maybe my reply in writing. Just the application of Bill C-11 when it involves multiple jurisdictions. As an example, the Reserve's 38th Brigade is training at CFB Wainwright at the Maneuver Training Center. And the sexual assault takes place. The victim is from the Winnipeg Rifles in Winnipeg. The accused is from the Armory in Thunder Bay, and witnesses might be from Regina and or Saskatoon. So you got the RCMP, you got different city police, you got the OPP. Who's doing the investigation?
If you could bring that in writing, that would be an important one. That's like multi-jurisdictional issues.
And that's where we get...
Yeah, and so it's a good question. So if we could respond to that, Deputy, that would be effective. Before we adjourn...
Similar examples.
If I could note, as we continue to study C-11, we should, I encourage all of you to bring forward the witnesses, hopefully by tomorrow, so that the clerk and the team can have some time to contact witnesses to appear before us. So please submit your witness list soon. For Thursday's meeting, the Deputy Commissioners of the Coast Guard are available to appear, so they'll be part of the first hour. And on the second hour will be NORAD modernization, and we'll have some witnesses appear before that. So we're good there. November 4th meeting, we have a conflict because we're all going to be supporting the budget presentation that afternoon. So we're going to miss out on our committee on that day.
Arrange it.
And well, we'll see how we can proceed in terms of rearrangement. And our next meeting, though, will be October 30th on Thursday. So we'll proceed, and then we'll provide some notification as to what that will entail. C-11 is the intent as we go forward, so we can resolve this issue. Ladies and gentlemen, with your permission, meeting is adjourned.